Hello friends, I am going to discuss with a chapter called the proposal or offer. The proposal or the offer, the word are synonymous and they are used interchangeably. Section 2A of the Indian Contract Act defines a proposal as when one person signifies to another his willingness to do or abstain from doing something with a view to obtaining the assent of that other person to such act or abstinence is said to make a proposal. From the definition, we can conclude the three essential elements is required in offer. First, the expression of willingness or abstain from doing something. Secondly, the expression of willingness to do or abstain from doing something must be made to another person. And third one, the expression of willingness to do or abstain from doing something must be made with a view to obtaining the assent of the other person to such or abstinence. Now we have to see what are the rules regarding the valid offer. The first one, offer may be express or implied. An offer may be made by words spoken or written, then the offer is called an express offer. And when the offer is made by other than the words spoken or written, that is by acts or circumstances of the case, then the offer is called an implied offer. The example of express offer, when A says to B that he would like to sell his car for rupees 1 lakh, this is an express offer. And in another way, if A says to B by telegram or by fax or by email wrote to him that he would like to sell his house for rupees 3 lakhs, then it is an express offer. Now the best example for the implied offer is the Transport Service Corporation when runs their buses on different routes carrying passengers from one place to another, then there is an implied offer made by the Transport Corporation. Now second rule is the rule as the offer must contemplate to give rise to legal consequences and be capable of creating a legal relations. If the offer do not intend to create a legal relations or legal consequences, then it doesn't come to an offer or it cannot be a complete contract. So the example is when A calls his friends to dine at his at his place or for a dinner party, then if B doesn't turn up for that, then A cannot file a suit against B, because this is of such nature of an agreement where they never intend to create the legal relations, though there is an acceptance is there, is also we cannot say that this is a concluded contract, because it is the agreement of such a nature of social or the domestic nature. That is why there is no legal binding agreement at all between the parties. Now the next rule is the offer must be certain and not loose or vague. So when the offer is not definite or certain, then it will not be called as a valid lawful offer. Example, A says to B that he would like to purchase his horse for rupees 50,000 and he will buy the second one from B, but if his first one will be proves lucky, then he will purchase. Now later on A has refused to purchase the second one, so B cannot file suit against A, because here there is no certain or the definite offer is made, and therefore there is no concluded complete contract is there. Now the next rule, the offer may be distinguished from an invitation to offer. An invitation to offer is not an offer, because it is simply that inviting the other persons to come and make an offer, but it is not an offer in the eyes of law. Best example is an advertisement for the sale of goods by auction. It is not an offer, because it is simply an inviting the customers to come and make an offer. So in this auction sale, an actual bids at the auction is the offer, and if the highest bidder superseding the previous one, then it will be amount as an offer. Otherwise it is simply an inviting the other persons to come and make an offer. Similarly, the catalog menu for a restaurant or the prices tagged on the goods displayed in the shopping mall or shopping center, it is not an offer, but it's simply an invitation the customers to come and make an offer, and therefore there is no concluded contract at all. The next rule is the offer must be specific or general. So offer may be specific because it can be made to a specific person, and the other type of a offer may be general. That means the offer can be made to a public at large. So if anyone will fulfills the terms of the offer, then it can be amount as an acceptance of a general offer. The best example for general offer is Curley versus Carbolic Small Gold Company Limited. This is a famous case. The facts is everybody knows about it. So the decision is only that we can say the company was here held liable because the Mrs. Curley, who has accepted the contract by fulfilling the terms laid down in the contract, and therefore the company was held liable. The next rule is that offer must be communicated. So offer must be made to a person and it must be communicated to him. It is not like that offer is made to the person, that's all, but he must have a knowledge of the offer. So therefore the example we can give here, that is Lalman Shukla versus Gauri. That is a very famous case, and the first case where it was decided that offer must be communicated to the person to whom it is made. So here the Gauri who has advertised for a reward of rupees 1000 if anybody will trace out his missing nephew. He is a Lalman who is a servant here. He left out the moment he came to know that his nephew has been missing. So he left out for tracing out the nephew, and he came back with find out nephew, and later on he has looked into the newspaper and came to know as he has given an advertisement and reward is 1000. So he simply asked the Gauri that I should get my reward now because I have find out that nephew. But here the drawbacks or the defects in the case lies with that. So Gauri and Lalman could not knew about the offer made with a reward of 1000. So that is why he could not succeed this case. The next rule is that the offer must not contain a term the non-compliance of which will amount as an acceptance. So it should not contain a term and which will amount as an acceptance. The example here is that if you have made a contract, you made an offer, and it was presumed that he has accepted the offer, because it will not in the eyes of law there is not an obligation on the offeree that he must accept the offer. He may or he may not. Therefore it should not contain a term the non-compliance of which will amount as an acceptance. The next is that next rule, the offer may contain any term and conditions. That means the offerer can make a terms that is regarding the time of the acceptance and the prescription or the mode how he will accept the offer. It can be done. So that is legally valid reason we can give. And the last legal rules, that two identical cross offers do not make an offer. If suppose offerer made an offer, and similarly the offeree has also made an offer to A, so that both of them's offer has been crossed at a transit, then it will not a concluded offer and acceptance and agreement, because both are in a position that no one knows about their facts of the offer and as well as the acceptance. So these are the rules when you are making an offer. If you don't follow this rule, there cannot be presumed to be an offer or acceptance and agreement, and therefore it may not amount as a concluded contract.